Void marriages. What are the types of void marriages? 1. Absence of any of the formal or essential requisites under Article 35. 2. Bigamous and polygamous marriages under Article 35, Paragraph 4. 3. Subsequent marriage upon reappearance of spouse, Article 42. 4. Bad faith of both spouses in the subsequent marriage under Article 41. Psychological incapacity, Article 36. 6. Void subsequent marriages under Article 35, subsection 6. 7. Incestuous marriages. And 8. Void by reasons of public policy. Article 39 of the Family Code states that action or defense for the declaration of absolute nullity shall not prescribe. Absence of requisites. First, void marriage, absence of requisite. Void from the beginning under Article 35 of the Family Code. Marriage where any of the party is below 18 years of age, even with the consent of parents or guardians. B. Marriage solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had legal authority to do so. Note there, though, that one's belief in good faith that the solemnizing officer had the required authority is a mistake of fact and not of law. C. Marriage solemnized without a valid marriage license except in marriages under exceptional circumstances. D. Bigamous or polygamous marriages not falling under Article 41. Okay, ang Article 41, ang bigamous marriage ato is subsequent marriage by present spouse who obtain a declaration of presumptive death for absent spouse prior to the subsequent marriage. E. There is a mistake as to the identity of the contracting party. And F. Subsequent marriages that are void under Article 53 or non-compliance with Article 52. To be considered void on the ground of absence of marriage license, the law requires that absence of such marriage license must be apparent on the marriage contract or at the very least supported by a certification from the local civil registrar that no such marriage license was issued to the parties. Alcantara versus Alcantara, 2007. Bigamous marriages. Bigamous and polygamous marriages. B. What are the elements of bigamous marriages? 1. The offender is legally married. 2. Marriage is not legally dissolved. 3. Offender contracts a subsequent marriage. And 4. Subsequent marriage has all the essential requisites for validity except legal capacity. From the case of Capili versus People, 2013. No judicial declaration of nullity. A person entered into a subsequent marriage without first getting a judicial declaration of nullity of the first void marriage makes the second marriage void, bigamous or polygamous. Presumptive death. Failure of the spouse to present to obtain a judicial declaration of presumptive death before entering a subsequent marriage under Article 41, so it's also falling under bigamous or polygamous marriages. Bad faith of both spouses, where both spouses entering a subsequent marriage after presumptive death who acted in bad faith. It is not settled that the fact that the first marriage is void from the beginning is not a defense in a bigamy charge. As with voidable marriage, there must be judicial declaration of the nullity of marriage before contracting the second marriage. The case of Mercado versus Tan, 2000. The accused may be charged with the crime of bigamy even if there is a subsequent declaration of the nullity of the second marriage, so long as the first marriage was still subsisting when the second marriage was celebrated. Capili versus People, 2013. Subsequent marriage when one spouse is absent. Requirements for subsequent marriage to be valid where prior spouse is absent. So, ma-valid gihapon ang subsequent marriage even if present ang absent spouse. Absent ang absent spouse. A subsequent marriage due to ordinary absence where 1. Absent spouse had been absent for 4 consecutive years. 2. The spouse present had a well-founded belief that the absent spouse is dead. And 3. Judicial declaration of presumptive death was secured. No prejudice to the effect of the reappearance of the absent spouse. B. Subsequent marriage due to extraordinary absence, where 1. Absent spouse has been missing for 2 consecutive years, and 2. There is danger of death under the circumstance set forth in Article 391 of the Civil Code attendant to the disappearance. For example, on board a vessel lost at sea, voyage, or airplane. 2. Armed forces in war or danger of death under other circumstances, existence is not known. 3. Ang third nga extraordinary absence is the spouse present had a well-founded belief that the missing person is dead. And 4th, judicial declaration of presumptive death was secured. No prejudice as to the effect of the reappearance of the absent spouse. The belief of the present spouse must be the result of the proper and honest to goodness inquiries and efforts to ascertain the whereabouts of the absent spouse and whether the absent spouse is still alive or is already dead. This is drawn from the circumstances before and after the disappearance and nature and extent of inquiries made. Case of Republic versus Granada. Effect of reappearance of absent spouse. Generally, the subsequent marriage remains valid if mobalik ang absent spouse. Valid gyapon ang second marriage. Except, it is automatically terminated by the recording of the affidavit of reappearance by the absent spouse at the instance of any interested person without notice to the spouses of the subsequent marriage. Kuya ba, may bawang ta sila nung anibalik na ang absent spouse. Note, it is the recording of the affidavit of reappearance that automatically terminates the subsequent marriage. Hence, if absentee spouse reappears without recording affidavit of reappearance, then there is no legal effect. Meanwhile, absentee spouse cannot remarry. Exception to the exception, if there is a judgment annulling the previous marriage or declaring it void ab initio. So, makamarry na siya if ang subsequent, previous marriage was already, kibali ang first marriage sa present spouse is void ab initio, then the absentee spouse can remarry. Good faith. Period of absence for presumptive death is mandatory and thus cannot be shortened by good faith, and if done so, will be void. This period is counted from when the party last heard of his or her absentee spouse. Jones versus Hortigella, 1937. Katunay si Angelica Jones, Angelita, Angelica, whatever. What are the differences between absence in civil code and the family code? As to period, kung sa family code under Article 41, 4 years under normal circumstances, pwede na. If extraordinary circumstances, 2 years lang. As to period in the civil code under Article 390, the absentee must be absent for 7 years, at least. If extraordinary circumstance, 4 years lang. In the family code, as to remarriage, in order to remarry, there has to be a summary proceeding. As to remarriage in the civil code, declaration of presumptive death is not necessary. Okay. Next. As to who can institute the action in the family code, can be instituted by the spouse present, any interested party, and the subsequent spouse. Under the civil code, the spouses themselves. As to the effect of subsequent marriage in the family code, subsequent marriage is automatically terminated by the recording of an affidavit of reappearance of the absent spouse. As to the effect on the subsequent marriage in the civil code, Upon reappearance, the judicial proceeding is necessary to declare the marriage null and void. As to the ground of absence in the family code, well-founded belief that the absent spouse is dead. In the civil code, as to the ground of absence, generally believed to be dead. Okay. Related provision. Under Article 390 of the Civil Code, after the absence of 7 years, it being unknown whether or not the absentee still lives, he shall be presumed dead for all purposes except for those of succession. Ang minimum sa Civil Code under Article 390, 7 years lang. Pero if exceptional circumstances or when there is the presence of danger, 4 years. Pero when factoring in succession, an absence of 10 years will open the succession. Exception to the exception is when you are 75 years of age. What is needed for succession to be opened is only an absence of 5 years. It is already sufficient to for the succession to be opened. The following shall be presumed dead for all purposes, including the divisions of the estate among the heirs. 1 or A. Person on board a vessel lost during a sea voyage, or an airplane which is missing, which has not been heard of for 4 years since the loss of the vessel or airplane. B. A person in the armed forces who has taken part in war and has been missing for 4 years. C. A person who has been in danger of death under other circumstances and his existence has not been known for 4 years. Take note, although 7 years is required for the presumption of death and of an absentee in the Civil Code, the Family Code makes an exception for the purposes of remarriage by limiting such requirement to 4 years. Okay, next, void marriage is bad faith of both spouses. Void marriage because of the bad faith of both spouses. Under Article 44 of the Family Code, if both spouses of the subsequent marriage acted in bad faith, the said marriage shall be void ab initio, and all donations by reason of marriage and testamentary disposition made by one in favor of the other are revoked by operation of law. E. Fifth, void marriage is psychological incapacity as provided for in Article 36 of the Family Code, a marriage contracted by any party at the time of the celebration was psychologically incapacitated to comply with the essential marital obligations of marriage shall likewise be void if such incapacity becomes manifest only after its solemnization. So what's the difference between psychological incapacity and vice of consent? Ang psychological incapacity has nothing to do with consent, but the incapacity to comply with the essential marital obligations of marriage, while the vice of consent is the consent itself is defective. How is psychological incapacity different from insanity? Psychological incapacity is where the consent might be valid, but the party is unable to assume essential marital obligations, while in insanity there is vice of consent. Psychological incapacity is a ground for nullity of marriage, while insanity is a ground for annulment. Okay. The application of Article 36 is confined to the most serious cases of personality disorders, clearly demonstrative of an utter insensitivity or inability to give meaning and significance to marriage. Santos versus CA, 1995. The psychological illness that must have afflicted a party at the inception of the marriage should be a malady so grave and permanent as to deprive one of awareness of the duties and responsibilities of the matrimonial bond he or she is about to assume. Marcos versus Marcos, 2000. What are the 3 characteristics for determining psychological incapacity? Wala naman ni gamit sa kuan. Wala ni gamit karon sa tanandol. But yeah, just read it. Gravity. A. Gravity. It must be grave or serious, such that the party cannot carry out normal and ordinary duties of marriage under ordinary circumstances. B. It must be, or there must be juridical antecedents. It must be rooted in the history of the party before the marriage. And C. It must be incurable, or the cure is beyond the means of the party. Wa naman ni Molina doctrine. Just fucking read it. Molina doctrine of psychological incapacity. 1. The burden of proof to show the nullity of the marriage belongs to the plaintiff. This is to be investigated by the OSG for collusion. B. The root cause of psychological incapacity must be 1. Medically or clinically identified. 2. Alleged in the complaint. 3. Sufficiently proven by experts. And 4. Clearly explained in the decision. C. The incapacity must be proven to be existing at the time of the celebration of marriage. Such incapacity must be shown to be medically or clinically permanent or incurable. E. Such illness must be grave enough to bring about the disability of the party to assume the essential obligations of marriage. And F. The essential marital obligations must be those embraced in Articles 38 up to 71 of the Family Code as regards the husband and the wife, as well as Articles 220, 221, and 225 of the Code in regard to parents and their children. G. Interpretations given by the National Appellate Matrimonial Tribunal of the Catholic Church of the Philippines, while not controlling or decisive, should be given great respect by our courts. H. The trial court must offer the prosecuting attorney or fiscal and the Solicitor General to appear as counsel for the state. No decision shall be handed down unless the Solgen issues certification. From the case of Republic v. Molina, 1997. Psychological incapacity may be established by the totality of evidence presented. Personal medical examination could be dispensed with. Marcos v. Marcos, 2000. There is no requirement that the respondent be medically examined first. Republic v. San Jose, 2007. Stringent requirements set forth by Molina should be relaxed and applied case to case. To require the allegations of the root cause of psychological incapacity by an accredited psychologist may prove too expensive for the parties, but where the parties had full opportunities to present expert opinions, such will be weighed by the court in its decision. Ting v. Willis Ting, 2009. Examples of psychological incapacity. The senseless and protracted refusal of one of the parties to fulfill a marital obligation to procreate children, based on the universal principle that procreation of children through sexual cooperation is the basic end of marriage, is equivalent to psychological incapacity. A man can but won't is psychologically incapacitated. Choi v. CA, 1997. Pathological liar considered a psychological incapacity. Antonio v. Reyes, 2006. This case has also gave way to the fact that the church annulled the marriage. Marriages where both parties are afflicted with grave, severe, and incurable psychological incapacity shall likewise be void. Te v. Te, 2009. Note, both spouses have personality disorders. Sa kaninga case, Te v. Te. Incestuous marriages. Marriages between the following are considered incestuous and therefore void ab initio. A. Between ascendants and descendants of any degree, legitimate or illegitimate. B. Between brothers and sisters, whether full or half-blood, legitimate or illegitimate. Void marriages, because they are against public policy. Marriages between the following are considered against public policy and are therefore void ab initio. A. between collateral blood relatives, legitimate or illegitimate, up to the 4th civil degree. B. Between step-parents and stepchildren. Take note, step-brothers and sisters can marry because marriages between them are not among those enumerated in Article 38. C. Between parents-in-law and children-in-law. D. Between adopting parent and adopted child. E. Between the surviving spouse of the adopting parent and adopted child. F. Between the surviving spouse of the adopted child and the adopter. G. Between an adopted child and an illegitimate child of the adopter. H. Between adopted children of the same adopter. And I. Between parties where one, with the intention to marry the other, killed the other person's spouse or his or her own spouse. Article 38. The following relationships are outside the Articles 37 and 38 and therefore not impediments to marriage. A. Brother-in-law and sister-in-law. B. Stepbrother with stepsister. C. Guardian with ward. D. Adopted with illegitimate child of the adopter. E. Adopted son of the husband with adopted daughter of the wife. Bali. Adopted daughter of the husband, adopted son of the wife. I don't know. Non-compliance with the recording of requirement after the declaration of nullity. Subsequent marriages of spouses where the requirements of recording under Article 52 have not been complied with shall be null and void. The judgment of annulment or of absolute nullity of marriage, the partition and distribution of the properties of spouses, and the delivery of the children's presumptive legitimes shall be recorded in the appropriate civil registry and registries of property. Otherwise, the same shall not affect third persons. Under the Civil Code, no judicial declaration of nullity of previous marriage was required to contract a subsequent marriage. People v. Mendoza, 1954.